So when does a broken promise stop being just, well, a broken promise and turn into a full-blown federal crime? That's the huge question at the very heart of this fascinating case, Brandenburg v. Seidel. And believe me, the answer it gives is a really big deal in the legal world.
You'd think that's a simple question, right? Is breaking a promise a crime? But the legal answer is, well, it's way more complex than you might imagine. It really forces us to look beyond the promise itself and dig into what happened because of it.
Okay, so this whole story kicks off with a promise. You have one person making a pretty serious commitment and another person who takes them at their word and acts on it. The problem? That action led to a major financial loss. But this wasn't just some personal disagreement, it escalated way beyond that. And this is where things get really serious. The whole issue jumped from a simple civil dispute right into federal court, with the charge of mail fraud. Suddenly, we're not just talking about money anymore. Now, potential prison time is on the table.
So what in the world is mail fraud? Well, according to federal law, it's when someone comes up with a plan to cheat someone out of money or property, and here's the key part, uses the mail system to help make it happen. It's a famously broad law, and it's a super powerful tool for prosecutors because, let's be honest, almost any scam is going to involve sending something through the mail at some point.
Let's just break that down into plain English. For a prosecutor to win a mail fraud case, they have to prove three things. First, that there was an actual deliberate plan to deceive somebody. Second, the whole point of that plan was to get their money or property. And third, that the mail system got used somewhere along the line to pull it off.
So, for the person who lost all their money, the plaintiff in this case, it wasn't nearly enough to just stand up and say, hey, a promise was broken. They had to go further. They had to prove there was a direct, unbreakable line connecting that promise to their financial loss.
And this right here, this is the absolute key to their entire argument. It was all about the action they took. They had to persuade the court that the only reason they acted, and therefore the only reason they lost the money, was because that promise had been made in the first place. And that argument hinges on a really important legal idea.
That idea is called detrimental reliance. That might sound like a bunch of legal jargon, but what it really means is that you were reasonably talked into doing something based on what someone else said, and because you did it, you got hurt. It's basically the law's way of protecting people who, take others at their word when it really counts.
And this slide lays out the logic perfectly. Detrimental reliance isn't some fuzzy feeling. It's a clear three-step chain of events. First, a clear promise is made. Second, someone reasonably relies on it. And third, that reliance directly leads to a loss. The plaintiff had to prove every single link in that chain was solid.
But of course, there are two sides to every story. The defendant, Seidel, came back with a really powerful counterargument. They basically said, look, even if a promise was made, we're not legally on the hook for what happened. And their whole defense was built around another huge legal idea, the test of foreseeability.
Foreseeability is a massive concept in the law. It's like a big reality check. It asks a simple question. Was this outcome predictable? Could any reasonable person, standing where the defendant was, have guessed that their words would lead to this specific kind of harm?
I love this analogy. It's basically the domino effect test, right? If you push over the first domino, are you responsible when the 10th one falls? What about the 100th? The law says you're only responsible for the dominoes you could have reasonably predicted would fall, and the defense was arguing that the plaintiff's loss was a total surprise, a domino way, way down the line. So you can see how this whole case boiled down to a huge legal showdown between these two ideas. On one side, you have Brandenburg saying, your promise made me act, and that action cost me everything. That's detrimental reliance. And on the other side, you have Seidel firing back, whoa, hold on, your loss was way too random and unpredictable for me to be legally responsible. So, this is it. The stage is set for the court's final decision. The judge has to put these two powerful concepts on a scale. Was the plaintiff's reliance on that promise strong enough to outweigh the argument that the harm just wasn't foreseeable? And here are the court's actual words, straight from the decision. The chain of causation between the alleged misrepresentation and the asserted loss is, as a matter of law, too attenuated. Now, attenuated is just a fancy legal way of saying the connection was too thin, too stretched out, too weak. So there you have it. The verdict was crystal clear. The court sided with the defense. They decided that the plaintiff's loss was not a direct or foreseeable result of the promise. That chain of causation was officially broken. And because of that, the whole federal mail fraud charge just completely fell apart.
So why are we still talking about this case all these years later? Because it set up a critical guardrail in the law. A broken promise by itself is not automatically fraud. For it to cross that line into a crime, the harm has to be a direct and predictable outcome. These two ideas, reliance and foreseeability, they act as these crucial gatekeepers that stop every single broken promise from clogging up the federal courts. And that really leaves us with a huge question for today, doesn't it? I mean, we live in a world where promises are made in texts, in DMs, and emails, all things that can be screenshotted and saved forever. Does that digital paper trail make relying on a promise more reasonable? Does it make the harm more foreseeable? It really makes you wonder, how would a case like Brandenburg v. Seidel be decided today?